Hello and welcome. My name is Beverly Popek. I'm a Supervising Compliance Officer at the Office of Labor Standards Enforcement, OLSC, and I am your host for the day. Our office is here to help you understand your labor requirements, and we thank you for attending this webinar, specifically tailored and customized just for nonprofit grantees to understand citywide and contracting labor laws. So we are at session 3, the Fair Chance Ordinance, also known as the FCO. If you joined late or you don't have the chat box open at this time, we ask you to take a look on your bottom right-hand side and open up this particular feature. We're going to drop our URLs and corresponding and important information that'll help you understand the presentation. And Joyce just drops the schedule for today. Thank you. Materials and recording. A copy of the slides, a recording will be available and posted on our website within the next 24 hours. The URL is here. And again, Joyce dropped the URL in the chat box so you can have that info. And let's talk about how you can ask questions and get answers. There are multiple ways. During the presentation, we will answer your questions in the questions and answers box. So if you don't have that feature open, pop that open, send us a question. For this particular session, I'm going to be working in that questions and answers box and give you some answers. If I'm unable to answer your question during the webinar, it might be that we've selected your question to be answered live during our live question and answer session, which we have at the end of each session today. And if we're unable to do that, because sometimes time does not permit, we just get sometimes a lot of questions, we just can't answer right here and right now, we will email you the answer to the email address you've used for the registration to this webinar. So if there's another email address that you'd like us to use, please put that in your questions. And some of the questions may require more information, so you may be asked to contact us. So here we are. We are at session 3, the Fair Chance Ordinance. Again, I'm Beverly, and the presenter for this session is Jade San Diego. I'm going to be working in the questions and answers box, and Joyce Soro joins us again and for the chat box. So hi, Jade.
Hi, good morning, everyone. Thank you, Beverly. So again, my name is Jade San Diego, and I am a compliance officer with the Office of Labor Standards Enforcement. And for this session, I will be going over the Fair Chance Ordinance. So first, let's talk about who is covered. You have to determine if the FCO applies to your firm and to those applying for work at your firm. Under the FCO, a covered employer is anyone with 5 or more workers working globally, and the planned position must be based in San Francisco, working at least 8 hours per week. For employers with city contracts or other types of agreements, the FCO applies regardless of the number of employees. And again, the position must be based in San Francisco, working at least 8 hours per week. Now, the FCO is a process law. This means that there is a step-by-step process that the employers are required to strictly follow when it comes to applicants or employees with arrest and conviction records. Now, because the FCO is a process law, it requires a compliant hiring process. And I highly recommend you visit our website to access our FCO Employer Toolkit. This toolkit has sample documents strictly for employers to use. This will assist you in the step-by-step process. And also watch our FCO Employer Toolkit video series to fully understand the entire process. And these videos will go over more specific details that we will not be able to cover in today's session. It's just a lot of information. So just please make sure you take a look at that. Now let's go over what a compliant FCO hiring process looks like. Let's start at the beginning of this hiring process, which are the job announcements. So the job announcements cannot say that these applicants, or that cannot say that applicants with arrest or conviction records will not be considered for the position, nor can the job posting state that a background check must be passed. Um, the job announcement must clearly demonstrate compliance with with the FCO by including a statement that's similar to the language that we have on the slide, that says, pursuant to the San Francisco Fair Chance Ordinance, we will consider for employment qualified applicants with arrest and conviction records. So in order for the job announcement to be compliant with the FCO, it has to have that language or, of course, something similar. Next is the job applicants, or the job applications and interviews. Job applications cannot ask about an applicant's history of arrest or convictions. And during the interview, the employer also cannot ask about or inquire into arrest or convictions. Now, after the interview, you as the employer can make the decision to hire the applicant. However, if you choose to run a background check, you have to make a conditional job offer first. Again, if you choose to run a background check, you do not have to run a background check, but if you choose to do so, you have to make a conditional job offer first, which leads us to the next slide, making a conditional job offer. Once you make that conditional job offer to the applicant, then the employer can ask about convictions, unresolved arrest, and even run a background check. So I do want to clarify that OLSC does not require you to conduct a background check. The employer can make a decision to hire the applicant at any time during the process. Um, but again, if you choose to hire or if you choose to run a background check, there are 7 categories of information that should not be considered when reviewing the background report. The first one is an arrest not leading to a conviction, participation in a diversion or deferral of judgment program, convictions that have been dismissed or expunged, convictions in the juvenile justice system, a conviction that is more than 7 years old. Uh, th there are exceptions to this rule that I'll go over shortly. And then number 6, an offense other than a felony or misdemeanor. So, for example, a traffic ticket. And number 7, any decriminalized offenses such as cannabis convictions. Now, I want you to take note of number 5 as this one is one of the most common violations that we see. Employers should not consider a conviction that is more than 7 years old. Again, there are exemptions to this rule, and we'll go over that in this slide. So exemptions to prohibit information. Employers may consider convictions and arrests that are greater than 7 years old if the position that the applicant is applying for supervises minors or dependent adults, and anyone over the age of 65 or older. Employers may consider infractions when it is significant part of the job that they are applying for. So, for example, if driving was a big part of the job, then you can consider driving records from the DMV. Um, see here. So other exemptions are, or other exceptions are if your businesses or firm is regulated by federal or state laws that requires a specific hiring process for certain jobs, then this preempts the FCO, meaning the FCO wouldn't apply. Some examples are jobs in the financial services and insurance employees. So now let's go back to the compliance process. After conducting and reviewing the background reports, if there are no issues, then you can proceed with hiring the applicant. Again, you can make the decision to hire the applicant at any time in the process. However, if after reviewing the background report, you find an issue that you would like to look further into, then you have to conduct an individualized assessment. This individualized assessment, you have to consider the duties and responsibilities of the job and how the issue on the background report directly relates to what the person would be doing on the job. So consider things like how long ago was the conviction or unresolved arrest, how old was the person when it occurred, and then even consider any evidence of rehabilitation if this person has gone through rehab, if they've had any other jobs previously in the past that's similar to the one they're applying for. So those are things to consider. Now, after reviewing the applicant's criminal history and conducting that individualized assessment, you and you still decide not to hire the person, you have to give the person a copy of the background report, a copy of the individualized assessment showing why the job offer is being rescinded, and then you also have to allow the applicant at least 7 days to provide a response. So, for example, if there was an error in the background report, any mitigating circumstances, and evidence of rehabilitation, so some things to consider. Did the person perform the same job elsewhere since the issue on the background report? Does the person have reference letters or completed a rehabilitation program? So again, those are some things to consider. Now, following the 7 days, you need to conduct an individualized reassessment using the new information provided by the applicant. If the applicant needs more than the 7 days to respond, you can provide another period of time for the applicant to provide further information. So, an example of allowing more time is if the background report is incorrect and the applicant needs to provide documentation confirming the correct information, or the person is waiting for a recommendation letter, then you can provide more time for that the applicant to receive all that information. Then once you have all the information, you need to make a decision on whether to hire the applicant or not. Um, if you decide to not hire the applicant, you have to give them a final decision in writing with a copy of the reassessment and provide a copy of the FCO poster, as the applicant has the right to file a claim with OLSC. Um, so that's the whole process. That's what a compliant hiring process looks like. I do want to let you know that at any time during the process, all OLSC needs is just one error, one violation, one mistake to consider it a violation to the FCO process. Now let's talk about what the FCO does not do. So the FCO does not require employers to give preference to those with unresolved arrest or conviction records. It doesn't limit the employer's ability to choose the most qualified and appropriate candidates. It does not require, nor does it prohibit a background check. Now let's go over some common violations that we see for the FCO. The first one, employers asking about convictions on job applications. So again, you cannot ask about convictions on job applications or job interviews. The second one, employer refuses to hire an applicant based on a conviction that is more than 7 years old and the position doesn't meet one of the exceptions. So yes, this is a common violation. We see this all the time, and employers should not consider arrest or convictions that's more than 7 years old. The next one is employers imply that individuals with arrest or convictions will not be considered or hired. So, for example, languages or statements on a job application or a job posting that says, a background check must be passed. So languages or statements like that, that's also a violation to the FCO. And then continuing on with other common violations, employers conducting a background check before the conditional offer of employment has been made. So you cannot ask or request a background check before you provide that conditional offer of employment. And then number five, failing to provide a copy of the background report. A lot of employees don't get a copy, or a lot of applicants don't get a copy of their background report, and they have no idea why the job is being rescinded. And we get a lot of calls on that. So just make sure you provide a copy of that background report to the applicants. That is their right. They should be given a copy. Um, and then number six, failing to provide 7 days for applicant to review and provide a response. A lot of employers see something on the background and they say, nope, I don't want to hire you. Um, and they don't even provide that 7 days for an applicant to respond, to provide a response, either show that they went through rehab, any recommendation letters that they may have. So all of these are violations. And again, keep in mind, all our office needs is one violation to the FCO process to determine that your company did not comply. And with all of these steps, you can see how easily you can maybe miss a step or forget. So just make sure you utilize that employer toolkit. That's your step-by-step guide to comply with FCO and also provide you with sample assessment forms that you can use and make your own. So just keep that in mind. That's there as a resource for you. Some best practices, go to our website to review the ordinance, view and download the employer toolkit, and then watch the videos for more detailed information on the FCO. Remember that the FCO is a process law, therefore you have to take the necessary steps to be compliant with the FCO. Here is the website for the Fair Chance Ordinance, as well as our direct contact information. Please feel free to reach out to us with any questions. And again, the website, all of that resources there for you. Please use it. And then this brings us to the end of this session. Please submit your questions in the Q&A box. And I believe we have some time for live questions. Beverly?
Hey there, thank you so much, Jade. And folks, we do have some questions that we'll have to get back to you on, and I have selected some for the time we have available right now to ask Jade. So before we get started, I just want to say that we have a complete series of videos for the FCO toolkit, and we have sample documents for you to perhaps customize and use. When Jade said watch those videos, you could watch this video again. You could watch the other FCO videos, but definitely watch the FCO toolkit videos, and it'll take you step by step. So start with the first video. It's a sequential process. So that's something that I'd say to you here. And then let's see here. We do have some questions for you, Jade. I think the first question I have is, does the FCO require me to hire a person with a criminal history?
Okay, so no, the FCO requires that you conduct a compliant FCO hiring process. Employers ultimately decide whether to hire or not hire an applicant, taking into consideration the information from the compliant hiring process. So again, the FCO is just a step-by-step process that employers need to follow when considering applicants with arrest and conviction records, but no, the FCO does not require you to conduct or to it does not require you to hire a person with a criminal history.
That's right. And nor does it require you to conduct a background check. That's kind of the opposite, but we do get that question a lot. Something I want to say before we go to our next question is that a lot of our nonprofits here may provide services to seniors and youth. And if that is your situation and you're trying to hire for a position who will engage with your seniors and or youth, there's perhaps an exemption there for you. And some of you are aware of it. You were trying to clarify, but I just wanted to mention that. Number two, the next question I have here are what are the most common issues employers make under the Fair Chance Ordinance? They want to know some best practices and asking you as a compliance officer, someone working at OLSC, what do you recommend to avoid um, issues?
Yeah, that's a great question. So basically, it's when employers don't follow the entire process or they accidentally skip a process. There's many cases that I've seen that employers are asking about convictions during the interview process, or rescinding the job offer after a background comes back and then they see something that they don't like. And you as the employer, you can't do that. You have to give the employee a chance to respond to any concerns that you may have. So some best practices to avoid violations is that make sure you or the hiring team is aware of the process. Have a checklist if needed to help you stay organized during the process. And then again, fully utilize, I cannot stress enough, but fully utilize that employer toolkit that we have on our website. That's available for you to use. It has all of the different steps that you need to follow, and even sample documents that you can make your own. Yeah.
Thanks.
Mhm.
And then this particular question is about when can nonprofits run a background check? I mean, this Fair Chance Ordinance, you can run a background check, but when can folks run a background check? This is that question.
Mhm. So the running a background check is you after a conditional job offer has been made, then that's when you can basically run a background check.
Okay, and then I think I mentioned this one before, but is a background check required under the Fair Chance Ordinance? We had a couple questions that came in with that one.
So no, a background check is optional to conduct for an applicant. Keep in mind that background checks cannot be run until, again, a conditional job offer of employment has been made to the applicant. But it is not required. OLSC does not require it. Only this is optional for the employer if they want to run the background check.
Okay, this next question has to do with the job posting. This nonprofit wants to know um, for the job posting, what do they need to include in the job posting to demonstrate compliance with the Fair Chance Ordinance?
So basically it's that language, it needs to provide, they need to provide that, that's compliance statement regarding FCO pursuant to San Francisco Fair Chance Ordinance. They will consider applicants with arrest and conviction records or something similar. It doesn't have to be word for word, but something similar to that, that states, it's because of the Fair Chance Ordinance, they are complying with that, so they will consider those applicants.
Yeah, and if you go to our Fair Chance Ordinance webpage, the very first section gives you information about what's prohibited, what you should not be asking, and what you should never ever consider with the bullet points and information like that. I think I'm going to just drop that into our chat box with what is the FCO URL's webpage. Um, Next question and last question. Um, what if I find a violent conviction on the background check, such as murder? Can I automatically reject the job applicant?
So again, no, you have to conduct that compliant FCO hiring process. So again, remember FCO is a process law. It's a step-by-step process. So you have to conduct a compliant FCO hiring process, where you have to conduct a individualized assessment, provide the applicant 7 days to provide a response, and then they may even have evidence of mitigating circumstances, or it could have been an error on the background report. Um, you just have to make sure you have all that information before you make a decision to not hire that applicant. There is no automatic rejection because you saw something on their background that you didn't like. You have to go through the process because all LSC needs is one violation to determine that your company is not compliant.
Yeah, this is a process law, so follow the process. There's a lot in the process, but we have a toolkit for you. So I think the takeaway here is we'd like you to watch some more videos and also take a look at our toolkit, and we are here for you so you can follow up and ask questions. So that's going to conclude our Fair Chance Ordinance session. Thank you, Jade. Thank you, Joyce. We are going to start up again in 3 minutes with the Family Friendly Workplace Ordinance. Thanks.